Members, we have a quorum. I call to order the meeting of the panel. Agenda item number 1, information papers issued since the last meeting. The Secretary issued an information paper to members, the details of which are set out in the agenda issued on the 23rd of March. Agenda item number 2, items for discussion at the next meeting. The Secretary has issued to members a list of outstanding items for discussion. LC paper number CB brackets 1267/2026 brackets 01. Now, on the regular meeting in April, the meeting will be held at 10:45 in the morning on 27th of April, on Monday. The administration proposes to discuss the following items. 1. Enforcement of labor legislation by the Labor Administration branch of the Labor Department. That's the first item in the list of outstanding items for discussion. And 2. Processing of applications to the protection of wages on insolvency fund in 2025. That's the second item on the list. Do members agree to discuss the 2 items? All right, let's move on to the third agenda item, legislative proposal to ban smoking in all construction sites to enhance safety. I will invite representatives from the administration to come inside the conference room. Members, please note that this item involves a legislative proposal. All other LegCo members are invited to join the discussion of this item. Members who wish to speak, please press the request to speak button. I will now ask the Commissioner for Labor to brief members on the paper provided by the administration. As the paper number CP brackets 1267/2026 brackets 02. Good morning, members. On behalf of the Labor Department, I will brief members on the proposed legislative amendments for implementing a comprehensive smoking ban in construction sites to enhance safety. Since the tragic fire which occurred in Taipo in November 2025, there has been strong community consensus for implementing a comprehensive smoking ban in construction sites. Let me first brief members on the current situation for managing smoking in construction sites. Now, in general, in construction sites, outdoor areas that would include open air ground, external wall works, and rooftop, these are not designated as no smoking areas. So people, including workers, smoking there, in principle, do not contravene the relevant laws. But for construction sites with higher risk of fire, under OSH, Occupational Safety and Health legislation, there are some rules. So under Regulation 53 of the Construction Site Safety Regulations, Chapter 59I, if there are specific conditions, that is, there is flammable liquid or any mixture containing any such liquid or any substance or thing involving danger from fire being used or intended to be used in the construction site, the Commissioner for Labor may issue an order prohibiting smoking and the use of naked lights in a construction site. This is on a risk-based approach to regulate flammable activity. That is, under most circumstances, for construction sites that do not make use of flammable liquid and therefore is not of high fire risk, we can just rely on management of contractors. So basically, you can see in construction sites some slogans that would advise workers against smoking, and they will ask workers to perhaps smoke in a designated area. But these are not statutory requirements. These are just management measures imposed by the contractors. In general, if we see in construction sites there's someone smoking, or we have observed a number of cigarette butts, we will issue verbal advice to the contractors. further enforcement operation is currently restricted because we need more on-site evidence in order to act in accordance with the relevant occupational safety and health legislation. We have looked at existing legislation. We believe the level of regulation deviates from expectations of a smoking ban in construction sites. This is the background for which we are planning to introduce legislative amendments to implement a comprehensive smoking ban in construction sites. We have several directions in mind for legislative amendments. To prohibit individuals smoking in construction sites, we will adopt the statutory smoking prohibition requirements in no smoking areas under the Smoking Public Health Ordinance Chapter 371. And if a person has committed a smoking offense, the fixed penalty mechanism set out in the Fixed Penalty Smoking Offences Ordinance Chapter 600 will apply. The individual will receive a fixed penalty notice with a fine of $3,000 under the specific legislation. We will also amend Regulation 53 of the Construction Sites Safety Regulations. With this, we will have no smoking areas designated without reference to Chapter 371, which is why Regulation 53 will no longer apply. We will amend Regulation 53 to impose clear legal obligations on contractor responsible for a construction site and a contractor who has direct control over any construction work in the site to take all reasonable steps to ensure that no person smokes or carries a lighted specified smoking product or uses naked light to light a specified smoking product in a construction site. A contractor who violates the amended CSSR is liable on conviction to a maximum fine of $400,000 as stipulated in the current provision. We do not plan to make changes to this. We have also some stakeholders asking for whether Regulation 53 will target only high-risk construction sites. Will we have extra measures for the high-risk sites? How can we perhaps designate some no-smoking areas? For high-risk construction sites, it would mean there is greater use of naked lights or materials and equipment that have a higher risk of fire. To deal with this, we plan to make use of existing occupational safety and health legislation because under Chapter 59 Factories and Industrial Undertakings Ordinance, there are some general clauses for employers or other personnel in the construction site, including workers, if they do something that can pose a hazard to the safety of others. We can quote the relevant legislation to initiate prosecutions, and this will target in particular construction sites with a higher risk of occupational hazard, including fire hazard. So if one makes use of conducts high-risk activities while smoking, we will not only issue a fixed penalty notice, we will handle this with the relevant provisions under Chapter 59, and the maximum penalty is $3 million. Of course, that would depend on the sentence handed out by the court. For the employee, the maximum penalty is $150,000. With the proposed amendments implemented, we will have a two-tier structure to implement a smoking ban in construction sites. We will have a comprehensive smoking ban. We will also have occupational safety and health legislation dealing with the high-risk scenarios. You may know under the public health ordinance for designated smoking areas, there are designated no smoking areas that would not include indoor workplaces situated in domestic premises, private quarters, bed space, apartments. When we designate for construction sites to be no smoking areas, we also need to provide for some exemptions, and we have in mind exemptions. Some of the sites for RMAA works, that is repair, maintenance, alteration, and addition works, that would include, for example, indoor decoration works involving private residential premises. There may be external wall works for a particular unit, whereas the homeowner continues to occupy relevant premises, which is why we plan to designate exempt areas where domestic premises are occupied or private quarters are occupied by residents. These will be exempt areas. So we are trying to strike a balance between regulation and freedom within domestic premises. If the homeowner has temporarily moved out for the contractor to conduct works in their domestic premises, then the premises will be designated as a no smoking area. If the homeowner continues to occupy the premises, the home will not be designated as a no smoking area. This is how we are going to implement a clear way to carve out this scenario for exemption. As you know, most of the work under relevant laws will be enforced by Tobacco and Alcohol Control Office. But for smoking in construction sites, we will be empowered by the Secretary for Health, and we have Labor Department personnel conducting enforcement work. We will make sure to conduct inspections to manage the risk in construction sites and implement the smoking ban. In terms of timeline, we are full steam ahead with the drafting and technical work for legislative amendments. In the middle of this year, we expect to introduce the legislative amendments into the Council for scrutiny by members. If we can complete scrutiny of subsidiary legislation before the summer break, we hope to implement and enforce the relevant legislation within this year. We are also discussing with stakeholders, including site management personnel and labor unions. They, in principle, support our work to implement a comprehensive smoking ban in construction sites, but they do want to work with us on enforcement for coordination. So in the next few months, we will continue to liaise with relevant stakeholders on this. We're also working with our Department of Health, TACO, and the Smoking and Health Commission, as well as the Primary Health Care Commission, closely to encourage site workers not to smoke in construction sites and perhaps seize the opportunity to quit smoking. Not only will that lower the risk in construction sites, it is also beneficial to their health. we will work with the Health Bureau and the various bodies to help workers quit smoking. That's it for my presentation. I welcome members' questions. Thank you.
各位委員，
Thank you, Commissioner. We have assigned 55 minutes for this item. There are 17 members who have pressed the button. 3 minutes, please. Mr. Chen Pui-kong. Thank you, Chairman. Thank you, Chairman. I have to declare interest. I am a PR director of a construction company. I support the ban of smoking in all construction sites to enhance safety, and I support the legislative proposal. Safety should be our priority. There's been many fires caused by smoking. The legislative proposal asks the contractors responsible for a site and a contractor who has direct control over the work in the site take all reasonable steps to ensure no persons smoke in a construction site. The maximum fine is $400,000. What does it mean by all reasonable steps? Before the laws come into effect, will you publish a guidelines to clarify what all reasonable steps mean? Do we have to provide patrol records? Do we have to install CCTV cameras? How many should we install? So on and so forth. Do you have any concrete guidelines? Commissioner. Thank you, Mr. Cheng, for the question. Regarding the term all reasonable steps, it's impossible for us to set out all details in the laws. We've talked to the trade, and we do have a direction. When we ban smoking at all construction sites, contractors should adopt a zero-tolerance approach towards smoking. There are many ways for us to implement such an approach. It's been adopted at many construction sites. Say, for example, there should be enough notice reminding workers not to smoke. There are some sites that install lockers at the entrance, asking workers to keep those lighters or cigarettes at the lockers. Some construction sites set smoking areas at the vicinity of the construction site, and the smoking area should not cause nuisance to the public. The managers of the construction site should patrol the site. They are also reminded by the contractor to pay special attention to black spots where many workers tend to gather and smoke. If they see cigarette butts or if they see workers smoking, then they should help us in gathering evidence. And they should assist the Labor Department in the patrol and prosecution efforts. All these are reasonable steps that you can take. And these apply to construction sites of different scale and different nature. For construction sites that are larger and more mature, of course, you can install CCTV cameras to assist in enforcement. In the future, we will continue to talk to the contractors and subcontractors. There are steps that we must take. And after you have taken the steps, then as we take enforcement action, we will have regards to those factors accordingly. Mr. Rokshan. Thank you, Chairman. I have two questions. First, paragraph 8 says that the Labor Department will be responsible for all enforcement work related to smoking offense in construction sites. In the hearing of Wanfu Court fire, we learned that before the fire broke out, the Labor Department patrolled the site multiple times. However, no risks was identified. Is there any ways for us to improve the enforcement work to enhance the efficiency and effectiveness of such work of the Labor Department? My second question. I wonder if the government will introduce technology to assist in the enforcement work. Will they make use of drones or CCTV real-time monitoring system? Thank you. Commissioner, thank you for the question. As I said in my opening remarks, currently, for construction sites with flammable liquid, they are not NSAs. If we identify indirect evidence, say for example, if there's someone photographing a worker smoking in a construction site, that's not illegal. It creates risks. So the Labor Department, when we come across such a situation, we will follow up with the contractor so that they will adopt a fire prevention work. Smoking at construction site is not illegal. After the legislative amendment, smoking at construction sites of any scale, of any nature, is illegal. So we can issue fixed penalty notice when we identify someone smoking at the construction site. In the past, when people submit the indirect evidence of workers smoking at the construction site, we cannot sometimes take prosecution action. In the future, after the legislative amendment, we will be able to. Second, Mr. Chen asked if we can make use of technology to make our enforcement action, make our investigation more efficient. We're looking into it. Currently, we are already using drones to investigate and inspect construction sites. These are mostly targeted at working from height. In the future, if there's workers going to the roof or going to a place where no one can see them to smoke, then our drones will be able to capture them. We're looking into whether we can add more functions to the drones so that we can collect more notifications in a more speedy manner. We're looking into installing, say, infrared cameras to cater to the risk. Thank you. Mr. Chao Shi-chong, thank you. I fully support banning smoking at all construction sites. I have two questions. After the legislative amendment, I wonder what our strategies or manpower deployment will be. Currently, the TACO is taking enforcement action. In the future, the Labor Department will be responsible for all enforcement work. There are less than 400 safety inspectors currently. You have to make 70,000 inspections every year. I wonder if you have enough people for that. Will you establish a dedicated team for the construction sites? Do you need to add manpower? Will you establish a partnership with the construction site contractors? Second, it is said that you are going to designate exempt areas in construction sites. Will you encourage contractors to designate smoking areas at a safe location inside the construction sites? Will you mandate construction sites of a certain scale to set smoking area? This will prevent workers going to a place to hide and smoke. Thank you. Regarding manpower arrangement, as I said, we will make use of our current manpower to handle all enforcement work. We will include the smoking ban patrols in our duties. So we're not going to add additional manpower to our team. Currently, we adopt a risk-based approach as we conduct inspections, and we have to make a relevant adjustment. The fire risk of different construction sites vary. Currently, we pay attention to different things as we inspect different construction sites. Many fatalities happen at work from height, work in confined space. These are high-risk procedures, and we are going to continue to focus our inspections at these work procedures. We will make adjustment as we amend the legislation because we have to focus more resources on construction sites. As to whether we should designate smoking areas at construction sites, we noticed that there are larger construction sites setting smoking area inside their premises, but there is a disadvantage to such an arrangement because if we set a smoking area, it means that workers can bring lighters into the construction sites, and when we identify cigarette butts at the construction site, it's difficult for us to tell whether the workers actually smoke at the smoking area or some other areas in the site. So according to our experience, it makes it more difficult for the contractors to manage the site if we set a smoking area at the construction site, and it's more difficult for us to take enforcement action. So we have no plan to allow for the designation of smoking area in construction sites as we implement the ban. Thank you. Mr. Xu Kafai. Thank you, Chairman. After the Wanford Court fire, the department proposed a ban in all construction sites. I think that's a good thing. Initially, the administration proposed a ban of $150,000, and later it was adjusted to $3,000. I think that's reasonable because I think that $3,000 is deterrent enough. There are two parts to the amendments. If contractors do not take all reasonable steps to ensure that no person smokes, then they will be fined $400,000. So what steps should they take to fulfill the requirement? I believe that no proprietor or contractor want to be fined. The guidelines must be clear enough so that they know what steps they should take. Second, you said that in individual case of serious circumstances, say for example a person smokes in the vicinity of highly flammable substance, then the prosecutor will be fined $3 million and imprisonment of 6 months. Employee is liable to conviction to a fine of $150,000, imprisonment of 6 months. So what flammable substance are we talking about? So what is the distance between the smoker and the flammable substance before they will be prosecuted? Thank you. Commissioner, regarding what steps the contractor should take, I already talked about that as we answered Mr. Chun's question. One thing I'd like to add is that the contractor and subcontractors have been quite proactive in our discussion with them. I understand that they are publishing or preparing a best practice on prevention of smoking in construction sites. We encourage them to develop the best practice, and we ask them to communicate with us as they are preparing for it, we will provide them with our advice. The industry has been very proactive, and I believe that the best practice will help us set the threshold. If we all think that the measures are reasonable and the contractors have taken those steps, then to a very large extent, the contractor will not be held liable. We will consider these as we take enforcement action. Second, on individual case of serious circumstances, as set out in paragraph 5, it's difficult for us to draw a line. Say, for example, within a certain meters, then a situation would be considered high risk. Apart from smoking, many different work procedures involve naked flames. There are hot works that involve gas cylinders or wielders. And there are some work processes involve highly flammable liquid. When these processes are in place, then the contractors and the managers are all responsible. We already have standards and rules in the current occupational safety regulations. We just specify smoking in the vicinity of highly flammable substance as cases of serious circumstances. Let me give you an example. If I smoke at an NSA, then I may receive a fixed penalty notice. But if someone smoke at a gas station as the gas pumping is in place, then they will be fined heavily under fire safety regulations. We believe that the construction site managers have relevant experience.
Well, with your penalties, it's $3 million and a 6-month sentence for employees. It would be $150,000 and 6 months imprisonment. It's not about there being an actual fire. As long as there's a risk, they can be punished. So I think you have to make clear in your guidelines what constitutes the relevant offense so as to minimize dispute in future. Anything to add, Commissioner? None? Mr. Mwunkit, I fully support the administration's proposed amendments to implement a comprehensive smoking ban. We have seen the fire at Wangfu Court showing it is not reliable to have construction sites implement their own rules. I want to ask if you will include possession of smoking products as a condition for contravening relevant laws. I also have a suggestion. We have other members talking about tackle. If they are going to be the authority receiving complaints, we will see a significant number of complaints being handled by them. We can perhaps implement a hotline for WhatsApp for people to just call or send photos to provide information on suspected smoking in construction sites. We also need to understand workers need some rest because of the intensity of their work. Will we still have a reasonable allocation for work hours and breaks for workers? Thank you, Commissioner. Thank you, Chair. I think it is hard to have in law to prevent someone from bringing specified products in construction sites, but we do understand where the member came from. When we discuss with the industry, we'll see if we can make use of guidelines or site management to convey a clear message to workers that they should not bring lashes into construction sites. We believe this can be beneficial. We have site management personnel communicating with enforcement officers, potentially contravening operations, but this is in general relevant to acts that breach the laws in construction sites. It does not target smoking specifically. We need the help of management personnel because no matter how many inspections we conduct, we have less exposure to what is actually happening in construction sites compared to site management personnel. So if they have found any irregularities and they submit the evidence to us for our enforcement, this can be a win-win for all. It is also how they can implement proper management of construction sites. As for the work and break arrangements in construction sites, there are many factors that are relevant: the intensity of their work, the weather conditions. Say for particularly high intensity work or when the weather is very hot, we have the manager having responsibility under occupational safety and health legislation to provide support to workers, including providing a covered rest area, water, and breaks for workers. And workers have the choice to just drink water or take a smoke break. But the site management personnel, of course, have to provide appropriate environment for different activities like these. Thank you. Captain Luther Lam. Thank you, Chair. I support the legislative amendments to implement a comprehensive smoking ban in construction sites. It will help enhance public safety. I have a question related to paragraph 8. It says the Labor Department will be responsible for all enforcement work related to smoking offense. I understand a particular division of the Labor Department will be responsible for that. The Commissioner said earlier they will not deploy additional manpower. How do they expect to implement and enforce a comprehensive smoking ban in construction sites without additional manpower? We will have perhaps the public calling TACO to make reports. How is coordination going to work? Commissioner. For OSH checks, we of course need to perhaps deploy additional manpower for that. We will not target particular acts with these inspections. We will just see if there is any deterioration in the occupational safety and health conditions. We will have, with such inspections, control over smoking as well. We therefore do not need much additional manpower, but we can depend on circumstances deploy more manpower for that. We cannot rely only on Labor Department personnel for comprehensive controls because we are like examiners. We are not the ones being with the students every day. So we really need the contractor and subcontractor to work with us. Of course, workers should be self-aware as well. They shouldn't just try to dodge inspections. They should deal with things head on. If they really want to smoke, they need to change their habits and work habits. Or if they choose to quit, that would be even better. That will tackle the root cause of the issue with the risk caused by smoking. Right. I believe I have answered all the questions, Chair. Well, can TACO take enforcement action in construction sites? Yes, they can inspect anywhere they have powers over, but then they are not as familiar with construction sites, which is why we propose for tobacco control in construction sites. We will have the Labor Department take over such enforcement work, but we do have some sort of coordination with TACO, because there are some areas that are not necessarily classified as construction sites, but they are in the vicinity, say communal areas in housing estates, lift lobbies, and these are areas where TACO would conduct inspections before. But for those areas frequented by workers, we will have mainly the Labor Department take enforcement action. We will make sure to have joint operations with TACO. There will be coordination. Okay, so there's some sort of joint mechanism in place. We have been working with the Department of Health on this, and TACO is under Department of Health. Mr. Lee Kuang-yu, I support a comprehensive smoking ban in construction sites. We have other members ask about 4.2, which is what I want to ask as well. If the contractor has already posted notices, provided training, would they be seen as having taken all reasonable steps? Honestly, with this expression, it is quite fake. The penalty is quite serious as well. Also, I think there should be a smoking area in the vicinity of construction sites. Instead of taking an across the board approach, this should make people less motivated to smoke in secret. Can we have contractors work with the Labor Department? And we have some unlikely scenarios, but possible scenarios where we have workers have cigarette butts stuck to their shoes and get into construction sites. Will they be punished still? Commissioner, the members' questions is on what is seen to be having taken all reasonable steps. If you read the paper, you understand our approach is two-tier. We ask site management personnel to take all reasonable steps. We do not ask site management personnel to make sure no workers smoke at all in construction sites, or if a cigarette butt is found in the construction site, they would have already been seen as having breached relevant laws. Because even with measures implemented, for example, with traffic lights, there are still people who will run red lights. So what we look at is just that the contractors have implemented the reasonable measures. if you see cigarette butts scattered across the construction sites, many of them, and there is evidence of workers smoking in the construction sites, and the site management personnel can't say what additional measures they have implemented to prevent that from happening, then they're at risk of being prosecuted. But then if they have implemented all the basic management measures and they have tried their best to make sure the measures are implemented, the enforcement priority will probably be on the worker then. In drafting, we actually make this distinction very clear. We hope that site management personnel can be familiar with such guidelines so as to work with us on enforcement. Mr. Ken Wong.
Thank you, Chairman. I support the ban of smoking in all construction sites to enhance safety. Do you have any standards on what all reasonable steps mean? The Commissioner said that it's difficult for them to set out all scenarios in the laws. I see some notice being put up at construction sites. I have some questions. If the contractors contravene the regulations multiple times, will you introduce a progressive fine approach? And will we, say, establish a marking scheme for contractors or construction sites? And I wonder if the administration will disclose the fire risk assessment or a number of incidents occurred in some specific constructions when they promote a smoking ban, and will they make the regulations more strict for construction sites with higher risks? Commissioner, thank you. Regarding the 400,000 fines for contractors under the Construction Site Safety Regulations, the SSR, that's the maximum fine that we can implement. Regarding the actual fine to be handed down to individual contractors, that's up to the court. The member asked if we should adopt a progressive approach. Well, this $400,000 fine is already progressive in nature. The specific fine can range from a few $1,000s to $100,000. That actually depends on the severity of the contravention and whether the person in charge have contravened the regulations multiple times. The court will make a judgment accordingly. If the contractors or subcontractors are prosecuted or charged, the record will affect their marks under the item of being a safe and responsible employer in the tender assessment. I understand that the trade is very concerned about the performance in this item, because when we assess the tenders for public works projects, if they have such a record, then it actually affects their marks in our tender assessment. We're not blacklisting them, but we think that we do have an incentive for the contractors to comply with the laws. As for the risk assessment of different construction sites, as we conduct inspections, we take enforcement action accordingly. We don't have an assessment for the construction site based on one specific factor. As we have more experience in law enforcement on construction sites' fire risks, we may hold more briefing for the sector. For high-risk work such as work from height, We do have many briefing sessions, many case sharing, and operational recommendations for the sector. As for fire risk, when we have accumulated sufficient experience and data, we are happy to share with the trade. Mr. Aaron Bach. Thank you, Chairman. I have to declare interest. I'm not a smoker. I fully support the legislative amendment because we need to make sure that our construction site is safe. But we have to understand that the ban is imposed because we want to reduce fire risk, not to ensure the workers' health and safety. Employees will be fined $3,000 if they smoke in construction site. For the proprietor and contractors, they are fined $4 million, but they are not the ones smoking in the construction site. The fine imposed on contractors is 133 times higher than the one smoking. If a patron smoke in restaurants, they are fined $3,000. Employer are fined $50,000. That's 70 times of the patrons. The contractor's permit is issued under the CSSR. If they are fined, then the contractor's points in the tender assessment will be lowered, because when the government assess the tenders, they look into whether the fine has been imposed to the contractors under the construction site safety regulations. Can we just fine the contractors based on the Smoking Public Health Ordinance? If we don't assign a smoking area in the construction sites, then workers are forced to smoke on the streets, and that actually affects the image of a city. And it will encourage workers to hide and smoke. Of course, we can install CCTV cameras, but cameras cannot capture each and every corners. Some workers hide behind the concrete bags or cement bags. So I think that the government should allow the person in charge of the construction sites to set smoking areas in the venue. We can place fire extinguisher at the smoking area and ask the workers to store their lighters and cigarettes in the lockers, so that this piece of legislation is more reasonable. So what does it mean also by contractors should be taking all reasonable steps? I think that the administration should be more clear. Commissioner. Thank you. Some of the questions put by Mr. Box have already been responded to. As to whether the fine imposed on contractors is too heavy, the ceiling of the fine, we believe, is reasonable. Regarding the specific fine handed down, it depends on the severity of the incident. The court will have regards to the nature of the case before they put down a fine. Under the OSH-related ordinance, for example, we don't see court handing down a maximum fine that often. As to whether we should issue a fixed penalty notice to contractors, we don't think that we should or can do so, because the contractors is not the one smoking. And we believe that the fine handed down should be proportionate to the nature of the contravention. So we don't think that we should be issuing a fixed penalty notice, regardless of the nature of the case, on the contractor. If contractors is charged and prosecuted, their points in the tender assessment will be affected. That's why the trade have been working very closely with us as to how they can take all reasonable steps to ensure no one smoking in the construction site. And we think, well, regarding setting the smoking area in construction sites, as I've already explained, there are many gray areas in terms of operation. it makes things more difficult for management and enforcement action. We think that by designating a smoking areas, it will complicate work. Workers should not be carrying their cigarettes as they work. Even if we designate a smoking area, they should go to the locker area at the entrance of the construction site. I think that instead of allowing them to smoke in the construction site, they could go to the locker at the entrance to collect their lighters, to collect their cigarettes, and go outside of the construction site to smoke. After turning the construction sites into NSA, will workers be hiding at more dangerous locations to smoke? Well, if I may take this opportunity to remind workers, after the laws take effect in the future, if workers go to high-risk locations in the construction sites, that is, if they go to places with flammable liquids, and if they smoke there illegally, then their fine would be higher than the $3,000 fixed penalty notice. They may be facing more serious consequences. Thank you. Mr. Lam Chun-sing, Deputy Chairman. Thank you, Chairman. Many members have asked about what all reasonable steps mean. The Commissioner said that by putting up notices in the construction site, that will not constitute reasonable steps. Should we ask the contractors to search the workers before they enter the site? After the best practice been published, if a fire breaks out and if the contractors have not complied with the code of practice or best practices, will they be convicted? When a place is under renovation, the resident of the place may smoke in public place. Will the contractors of the renovation works be responsible to remind the resident of the home that they should not smoke? You said that for high-risk circumstances, you will resort to general clauses to prosecute. So as long as you identify unsafe situation, you can charge the contravener with such a clause. Is the conviction rate high? What happens if the employers and employees smoke together at a location? And if the flammable substances are scattered everywhere, what happens? We amended the maximum fine to $10 million 3 years ago. Will anyone be charged with indictable offenses? Commissioner, regarding the responsibility of contractors. Workers are managed by contractors and subcontractors directly, so the contractors are definitely responsible for the action of workers. What happens if someone else walks into a site? Like any other construction sites, if a random pedestrians go inside the construction sites to take photos, for example, the contractors have the responsibility to manage that person. The contractors should either ask the person to leave or jot down their personal information. The contractors do have a management responsibility. Will legal liability be a reason because of the contractors not being able to manage outsiders entering a construction site? Well, that depends. Regarding RMAA sites, there could be a construction sites within a residential development. And sometimes some are not within the construction sites and they are managed by the management office of the development. And some places are under the purview of the TACO, some are under the Labor Department. If a resident enter the RMAA work to smoke, the contractors can either take photo of that person, ask them to leave, or submit the evidence to us or TACO or the management office of the residential development. Thank you.
真係好嚴。
Well, for the more serious cases, will you go with the indictable offense route? It really depends on the circumstances. With indictable offenses, it's not preventive. It's often when we have some serious incidents where there are casualties or deaths, and we have evidence saying that the management personnel have an indispensable obligation. And then we'll go with the indictable offense route. So for an act of smoking, and we can prove it's directly related to casualties and death, then we'll prosecute them with indictable offenses. Alright, so basically the Commissioner is ruling out such possibility. Mr. Chan Cho-Kwang. Thank you, Chair. We can see from the paper we have a more stringent approach in punishing those. But the problem is always with enforcement. If we had stringent enforcement, we would not have incidents happening in the first place. The paper doesn't touch on anything that enhances enforcement. In fact, it probably limits the scope of enforcement. Say for TACO officers, they will basically not take enforcement action in construction sites. And contractors, they of course have obligations. And before, when we saw someone smoking in cinemas, we can make a report right away, and officers will come not long after to enforce the law. What's important is enforcement. Otherwise, you can't effectively implement the law. Commissioner, thank you for the members' questions. With enforcement, you need to first have enforcement powers and how we can coordinate in enforcement. Without legislative amendments for construction sites that do not have a high fire risk, the Labor Department and TACO cannot enforce the law because smoking itself is not against the law. So we need to amend legislation to set down our powers for enforcing against such scenarios. After that, with powers, we can see what we can do in coordination and enforcement. As said earlier, the Labor Department personnel will conduct random inspections, and we will also look at smoking in these inspections. But we should not rely only on inspections because, one, we have manpower constraints. Two, as said earlier, we need to have the support of site management personnel, and we need to have good coordination with them. And in fact, site management personnel are inclined to work with us because they will be held accountable for any incidents. So they are motivated to work with us. Sometimes they might even provide evidence to us. As for in future, whether we will have some sort of coordination mechanism with, say, our partners or site management personnel, we would say in general we want to have information or evidence of someone smoking in construction sites, and then we can take enforcement action with such information provided to us. This will be another tool of ours to initiate prosecution. In future, we will enhance publicity in this regard. Chair, I am dissatisfied with the reply. We know there are issues with enforcement, but you did not say how you would enhance enforcement. No matter how many inspections you do, if there's another fire, you can just excuse yourself saying you have insufficient manpower. Will you hold relevant enforcement officers accountable as well? Under existing legislation, we have enforcement powers. We have more acts regarded as illegal under the amended legislation. Well, there's no point in their reply. You are saying you would take over TACO's powers, but then now you're saying TACO has power still. I think the commissioner never said TACO lost the powers to enforce against such acts. Commissioner, anything to add? I mention TACO specifically because we have site management personnel involved. We also have the property management office that will be responsible for such as well, and we want to coordinate with the different parties and stakeholders to enforce the law, to basically expand the scope of enforcement. But I think the members' concern is valid. We have in the legislative amendments delineating what is regarded as breaching the law. But after the amendments have come into effect, the focus will be on whether we are doing much in enforcement. And I think the members' concern is valid. Ms. Michelle Tang, first of all, I would like to thank the chairman for allowing me to speak as a non-member. With the tragedy of the Wangfu Court fire, we have different reform measures promulgated to prevent a tragedy like this from happening again. I do support the administration's amendments to protect workers' health and the safety of citizens. However, the industry has three concerns about implementation. First, the administration must clearly define the boundaries of construction sites to minimize dispute and enforcement. Second, contractors should have clear guidelines on what reasonable steps they have to take are. Thirdly, there should be a reasonable excuse and exemption terms so that when contractors have already done their best, they should not be punished. These are my suggestions. Commissioner, Ms. Tang talked about, basically expressed her views, gave comments. I already responded to most of them. I believe what hasn't been answered is some exemption terms. We will not spell out specifically which scenarios where one would be exempt from prosecution. As long as we have coordination with site management personnel and they have done their best to implement reasonable management, this is something we will consider before we initiate prosecution. We will liaise with the industry more so that they understand this. As for delineation of boundaries of construction sites, for occupational safety and health and construction related legislation, there is a legal definition of construction sites. When there is gray area, it's often because some of the spaces where works are being undertaken are also domestic premises. We will liaise with the industry to see with their delineation boundaries before they would have more areas included as construction sites to say where works are being undertaken, but in future we'll work with them to make sure they limit the scope of construction sites only to where works are being undertaken and where they can have control over their operations. Mr. Kingsley Wong, I support the legislative amendments. I don't smoke. I'm against smoking, but then I think we should account for the needs of smokers. We have seen some construction sites implement stringent smoking measures. The contractors will sometimes blacklist smoking workers. With unreasonable punishment imposed by contractors, what will the administration do? If the workers have breached the laws, of course we should impose the penalties concerned, but blacklisting, is it seen as something unreasonable? With the smoking ban in future, can we have designated smoking areas, say at the entrance? However, some workers complain to me that if they smoke outside construction sites, they have been penalized by TACO. So can we have specific solutions, for example, temporary smoking areas for workers so that they can smoke somewhere in the construction sites? I think there can be better coordination between Labor Department and TACO in terms of implementation. Commissioner, the two questions are: one, site management personnel practicing stringent management of smoking of workers. They will deduct points, blacklist workers, etc. This has something to do with labor relations. for punishment against employees or even termination of contracts, the punishment must be proportionate, even when the worker breach some of the rules. If the measure is disproportionate, it can become a labor relations dispute. We can intervene by introducing mediation. We, of course, want to make sure to be fair to workers, and the Labor Department can provide support to workers in mediation, but we hope workers understand they may need to make some changes to their habits. As for if one smokes outside construction sites, whether it can be enforced against. If it's a general public space, they are not queuing and they are not in the vicinity of, say, healthcare premises or schools. In general, smoking is not banned, but if we have too many workers smoking as a group, it can be a nuisance to the community, which is why we want to work with contractors to say if they arrange for breaks for workers and they know the workers smoke, they can arrange for them to smoke in an area. And if they can make sure to put in place a rubbish bin for cigarette butts, they can also remind workers not to cause a nuisance to the community, to maintain harmony with community stakeholders. We are more than willing to work with contractors on this.
Mr. Augustine Wong, thank you, Chairman, for allowing me to attend this meeting and speak. I have to declare interest. The institution that I work is in the real estate and construction business. The real estate and the real estate sector supports the ban, but I have a few questions. First, on the boundary of construction sites. There are many different types of construction sites. There are sites working on excavation of roads, on slopes, on NOLA. How do we distinguish between a construction site from a public space? Is there any gray area in terms of enforcement? I hope that the administration will define clearly the definition of construction site and public space. The cigarette butts in the construction sites may not belong to the workers working there. It could have been blown there from outside by the wind. Second, as I said, there are many different types of construction sites. There are larger ones, there are smaller ones. So I think that we should work with the trade to develop some best practices. After publishing the best practice, we should implement a exemption clause. If the contractors or developers have already taken all reasonable steps, will that constitute a defense? I think that we should allow for flexibility. Should we not allow some construction sites to designate smoking area with the consent of the Commissioner of Labor? There are some construction sites building smoking rooms for their workers. I think that we should allow for some flexibility for the contractors. Commissioner, thank you. I understand that the boundary and the size of construction sites vary. Sometimes a construction site may span across an entire residential development, and some are smaller, taking up a small area on the side of a road. As long as construction work is undertaken at a place, then it will constitute a construction site. Say, for example, if there is someone working on a slope, spraying paint on it, installing equipments thereon, all these are construction work. Usually, the construction site is defined. Sometimes it's defined by some temporary equipment, say, for example, metal barriers. The boundary should be clear. When we take enforcement action, we will look at the risks. If the site is small, if the work process is rather simple, if it's outdoor entirely, then we may not target such site as we conduct inspection because no one is living in such a small construction site. But if we identify contraventions inside such a small construction site, we will look at the nature of the case. We will not be charging anyone if we simply see a cigarette butt inside the metal barrier. We will exercise our discretion as appropriate when we take enforcement action. Regarding the details of the reasonable excuse defense, I already said it earlier. If we identify smoking risk related evidence, and if the managers of the construction site is able to demonstrate that they have taken all reasonable steps and measures to ensure no one smokes, then as we take enforcement action, we will only target the smokers instead of the managers, because the managers have taken all reasonable steps to make sure no one smokes. We will look at all individual circumstances, and we will be flexible in our enforcement. Our ultimate target is not to sue someone, to convict someone, but to ban smoking. As long as we can achieve our goals, we will resort to all reasonable means. You said that it was not an excuse in the court, but that's a factor you consider as a law enforcement department, correct? Mr. Jonathan Leung. Thank you. Since the Taipo fire, we've been advocating the administration in amending legislation to ban smoking in all construction sites. I support it, but I have some questions. First, on smoking area, the commissioner said just now that workers who smoke can go outside of the site to smoke. But that constitutes society cost. Usually, the pavement outside the construction site is very narrow. We've received many complaints saying that construction site workers smoke outside the construction site. Many roads or pavement outside the site are patroned by many students and children. And if there are many workers if there are many workers smoking outside the construction site, then it will cause complaints. And I understand it's difficult for us to allow construction site contractors to set smoking areas, but I think that we can address it, and I think that the administration can allow the construction site to designate smoking areas. If workers are able to smoke within the smoking areas in the site, then we will receive fewer complaints. And some workers may kick the cigarette butts out of the construction site to avoid liability. There are many benefits to designating smoking areas in the construction site. Please consider it. Second, If there is a flat in a private residential development under renovation, then the flat will be designated as a NSA. What happens if the owner of the flat come home to see someone smoking in the flat? Can they take photo of the cigarette butts and send it to you? Will that be enough for you to take enforcement action? If enforcement action cannot be taken after legislating, then people will be dissatisfied. Commissioner, thank you. The member talked about the idea of designating smoking areas and construction sites. I've talked about it many times. I will not repeat our considerations. But as a general principle, our laws and our rules should be up to date. After enacting the laws, after we have accumulated experience, we will see if it's effective for us to ban smoking in construction sites across the board. And we will look into whether it's a best ways for us to protect the community and the best management approach for construction sites. Of course, we can review it later on. But as a first step, I think that, well, this new piece of legislation will be something that the construction site contractors and workers have to get used to. I think that by clarifying their responsibility, it's better for everyone. Regarding renovation works, RMAA works, and private residential developments, it's difficult for us to take enforcement action based on evidence sent by residents. Let me give you an example. There is a resident taking photo of workers smoking at scaffolding. Even if we received such a photo, we cannot take enforcement action because currently smoking is not banned in construction sites. In the future, after the amendment is implemented, we can take enforcement action. But then still we have to look at the environment. We have to verify the authenticity of the photo. We have to identify the smoker. After the legislative amendment, the challenges that we currently face can be addressed. Because now we can only charge someone when we see a worker smoke while having flammable substance nearby. In the future, as long as we have indirect evidence, we can take enforcement action. Ms. Kwok Foo-yong. Thank you, Chairman. The Labor Department is proposing this legislative amendment to ban smoking in construction sites to enhance safety. I support it. But I have some questions regarding enforcement details and the responsibility of employers and employees. Many members who spoke are concerned about this request on construction site contractors having to take all reasonable steps to ensure no one smokes in construction sites, otherwise we'll be fined $400,000. The administration have not explained the rationale behind it in the paper. The administration just now said that they're going to develop a best practice for the trade. I hope that the commissioner will explain further about what all reasonable steps means to alleviate the concern of the contractors. The maximum fine of $400,000 for contractors is much higher than that for the smokers. I'd like to know more about the justifications for such a fine, and have you considered the level of fine for CSSR? Currently, the laws is not clear enough. For persons who smoke at construction site, they are fined at $3,000. As many people have said, the environment in construction site is rather complex. I'd like to ask about the RMAA works at private residential developments. It is said that the inside of a RMAA works is included as an NSAs, but outdoor areas of construction sites are not. And it is also said that if a resident is occupying a premises, then it's not a NSAs. There are many flats within residential developments. If there is major renovations going on in the residential developments, there are many people going in and out of the estate. In the existing legislation, there is no clear definition of the boundary of construction site. Ms. Kwok, please leave some time for the administration to respond. Just now, the commissioner have replied to some of these issues, but they're not clear enough. I hope that they will explain further to the people. How will this new amendment apply if there is major renovations going on in the residential development? I fully support the ban in construction sites to lower fire risk, but I hope that as the administration submits the proposal, they will have to ensure that there is a balance between protecting public safety and responsibility of workers. Thank you.
Members, this is a legislative proposal. I will not interrupt you, but you have gone way beyond the time limit. I will ask the commissioner to give a brief response. If members have any further questions, please, we will perhaps have the Labor Department give a written response. Commissioner, we have been liaising with the industry. We want to give them comments once they have prepared, say, the guidelines. With coordination, I believe we will work great together. For penalties, for the fixed penalty, it will be $3,000. It will apply regardless of the risk. Say if one smokes in an open air area where there's nothing in the vicinity, we can still issue the fixed penalty notice of $3,000. As for the more serious penalties, there is a cap. How much of a fine will actually depend on what the court gives in sentence. The nature of the two penalties are actually quite different, so we can't really directly compare them. For workers, if their acts are more risky, in accordance with general duty provisions, they can be handed a $150,000 fine. This is an existing provision, so we do not really need to make any changes to implement this. As for maintenance works, we have in mind an exempt area being occupied domestic premises. If one is outside the premises, say in the left lobby or in a communal space of the housing estate, it is not regarded as a no smoking area. For one working outside the window of the unit, it is a works area, so it is also a no smoking area. We believe the distinction is quite clear. But of course, after the relevant laws have passed, we will make sure to explain to the public what the laws entail. Due to time constraints, I will draw the line after Dr. Alvin Lee has spoken. Mr. Lam Wai Kong, thank you. I very much support the administration's proposed amendments, but I also want the administration to think about delineating smoking areas for workers in construction sites. If they can't smoke in construction sites, they smoke outside, there may be other problems. I think the best way is to designate an area for smoking in construction sites. Say beyond the entrance, but before we enter the boundary of construction sites, we can have a smoking area for workers. As for enforcement against workers or contractors is relatively unclear. If one is smoking and they're caught, we should punish them. But then if you're just counting the number of cigarette butts in construction sites, or we have drones that have identified workers smoking, but we can't say who it was specifically, how are you going to enforce the law? Can the department work with labor unions and the industry and explain to them the specific requirements? Can you also publicize to workers the serious consequences of smoking? Many of the questions are repeated. I will just ask the Commissioner to give a brief response. Commissioner, thank you for designation of smoking areas. I've given a reply on that several times, but we do note Mr. Lam's comments. We take a two-pronged approach with enforcement and education. Apart from taking enforcement action, we believe it is important to change behavioral habits in order to ensure occupational safety and health. We will do more work in education in this regard. We are also working with the Department of Health and TACO to encourage workers to quit smoking. They have allocated some resources for the Labor Department to work with the Department of Health to provide smoke quitting service and counseling to workers with such needs. In future, we hope to work with labor unions to encourage workers to quit smoking. Thank you. Dr. Alvin Lee. Thank you, Chair. I absolutely support the proposed legislative amendments. With enforcement, we need to make sure people know they should comply with the laws in the first place. I think with publicity, you have to convey that message clearly instead of encouraging workers to quit smoking. And we want to make sure workers comply with the requirements voluntarily. Can we do more so that workers more voluntarily abide by the law? Commissioner, I agree with what Dr. Alvin Lee said. With construction sites, we are trying to mitigate the safety hazard. The focus is not on encouraging workers to quit smoking, and the enforcement focus is the occupational hazard related to improper handling of cigarette butts and nicotine lights. This is what we'll focus on in education. We try to have charters to encourage workers to build good work habits, and we have been making use of this approach to promote good practices in the industry. As for us implementing a smoking ban, we want to, apart from imposing penalties, encourage workers and companies to comply with the charter. Thank you. We have all members asking questions. the administration plans to submit the proposed legislative amendments in the middle of this year to the council. Any comments on this, members? No objections? Thank you. Agenda item number 4, Good Employer Charter 2026. I will ask representatives from the administration to come inside this conference room for a discussion of this item. Members who wish to speak, please press the request to speak button.
我先請勞工處副處長簡
I will now ask the Deputy Commissioner for Labor to brief members on the item. Thank you, Chair. We would like to brief members on the Good Employer Charter 2026, the situation. We have the paper also talking about services that will help unleash labor force potential. The Labor Department has been promoting good human resource management on 3 levels: the public, industries, and enterprises, to strengthen promotion on good human resource management and family-friendly employment practices. We have promoted Good Employer Charter in 2020-2024, and now we have the number of signatories close to 1,600 in 2024. It is a significant increase from 2020 of over 60%. This year will be the 4th year we're promoting Good Employer Charter. We have the theme of work-family balance, strive for brilliance. We want to work in tandem with the 2025 policy addresses measures to promote childbearing. We encourage and recognize employers' efforts to provide support to employees in good human resource measures, such as supporting the family needs of employees, providing care to employees, employee benefits, and employer-employee communication. For the 2026 Charter, we, for the very first time, have the Family Council as a partner, as a supporting organization. We have the panel of judges comprising representatives of the Labor Advisory Board, as well as the Institute of Human Resource Management. For those who have become signatories of the Charter in 2026, they can make use of the logo of the Charter. And if they have implemented 5 or more measures, the employers can use the work-family balance together, strive for brilliance logo. For organizations that have participated in as a signatory for 3 terms of the charters, they are authorized to use a premium logo. The Labor Department has been publicizing in different channels the charter to encourage more to sign the charter. The Labor Department also has other measures to promote employment services. In July 2024, we have launched the Reemployment Allowance pilot scheme covering full-time and part-time jobs to flexibly cater for the employment needs of the older and middle-aged persons, including women. As at January 2026, we have very good participation, recording over 66,000 participants and over 38,000 placements, of which about 60% of the participants and placements were for women. we will continue to adopt different measures and publicity activities to encourage employers to make good use of good human resource management measures. The deadline this year is 31st of May. We hope more employers will support and join the charter to create a family-friendly work environment. Thank you, Chair.
原定嘅11時結束。
Our meeting was scheduled to end at 11 a.m. I will extend the meeting by 15 minutes. There are 7 members who have pressed the button. 3 minutes, please. Mr. Chao Chiu-chung. Thank you, Chairman. First, I have questions regarding Reemployment Allowance Pilot Scheme, REA scheme. It's been very effective. I hope that the administration will regularize it because it helps in unleashing labor force. I hope that the government will improve the scheme, taking the opportunity of the mid-year review. For employees staying in their job for 2 years, can we allocate extra bonus to the employers? For industries with manpower crunch, can we add extra subsidy for the employers or employees so that we can direct labor force to industries with manpower shortage? Regarding the Good Employer Charter, I fully support it. And we see results with the scheme. Over the past 20 years, well, if I remember correctly, some 20 years ago, we launched the family-friendly employment practices. But according to the CNSD statistics regarding flexible working hours or working from home, not many private organizations offer such an arrangement. Less than 5% of companies offer such flexibility for the employees. You said that there are 4 areas under the charter, and the employers should adopt family-friendly measures in all these 4 areas. Do you have any standards for assessment? Do you offer some indicators for participating companies? How do you assess if the companies have adopted the measures specified in the charter? Deputy Commissioner, thank you. I thank Mr. Chow for his support for the REA scheme. As he said, we are now conducting a mid-year review or midterm review of the REA scheme. It's been very popular. We will have regards to our experience in running the scheme and the relevant statistics before we regularize the scheme. But then we have to strike a balance. We have to make sure that the public money is used well to help job seekers in actual need. As for the Good Employer Charter, regarding the good human resources management measures, we will continue to encourage employers to value human resources management. We ask employers to undertake that they have implemented relevant measures before they can become signatories to the charter. When necessary, we ask the employers to provide supplementary information to make sure that the signatories meet the requirements under the charter. Chairman, we will continue to work on it. I believe that this will be an ongoing effort so far. We want to instill a cultural change in the industry so that more employers provide family-friendly employment practices. Mr. Lam Chun-sing, thank you. I believe that the administration wants to promote employment of single-parent, elderly. I hope that the administration will go beyond putting out slogans. I hope that they will implement measures to encourage enterprises to hire elderly or single parent. Flexible work arrangement is particularly important to them. I wonder if the administration will improve the charter to further encourage or motivate employers to step up their measures in these areas. Second, in paragraph 3 of the paper, it is said that the Labor Department will promote the charter through the tripartite committees. The industry-based tripartite committees are not just about the good employer charter. The administration said earlier that they will not going to legislate for the standard working hours, but the industry-based tripartite committees work on best practices of certain industries. By having the charter, we want to encourage employers and employees to strike a balance between the work and their family. If the employers comply with the standard working hours guidelines, then they should be considered a good employer. Under what the progress of the guidelines is. Deputy Commissioner, thank you. We want to encourage women, single parent to join the labor force. And I agree with what the Deputy Chairman said. We need to offer flexible working arrangement, part-time jobs to these people. We have included such considerations in the Good Employer Charter. We want to promote a cultural change in the community. The more employers join the charter, the better. By that, we hope that more employers will implement a flexible work arrangement or hours at the workplace so that more women, more elderly will join the labor force. The Deputy Chairman also asked about the standard working hours guidelines. Over the past, we have been working with employers, trade unions, from 9 industries to come up with a guidelines on standard working hours. We've been working on reaching a consensus, but on the number of hours, on the overtime pay calculations, there are still diverging views. As of right now, I don't think that is easy for us to reach a consensus. The Labor Department will continue to encourage employers to roll out good practices. Thank you. Mr. Jonathan Lang. Thank you, Chairman. On unleashing labor force, it is said that the Labor Department launched the 3-year re-employment allowance pilot scheme in July 2024, and the scheme recorded over 66,000 participants and over 38,000 placements as at January 2026. About 60% of participants in placement were women. Out of the 38,000 employees, how many of them were able to obtain the subsidy by working 12 months at the same job? Any room for improvement? Deputy Commissioner, thank you for the questions. I will ask Ms. Fong, Senior Labor Officer, to talk about the figures. As mentioned in the paper, the REA scheme have been better received than we expected. We have quite a number of successful cases. After joining the scheme, the participant can look for jobs in various ways. Of course, the Labor Department can offer our service. Some participants may have just joined the scheme recently. They may be still on the look for jobs. As for the figures regarding specific cases, I will ask Ms. Fong to elaborate. Thank you. Thank you, Chairman. Thank you, Mr. Leung, for the question. Regarding the REA scheme, as said, February 2026, we received 40,000 declarations of employment. About some 30% are carers of children or housewives. Some 10%, nearly 10%, are retirees who re-entered labor force because of the scheme. About 60% are women. Regarding age groups, from 40 to 59 years old, they account for 70%. 60 to 60 or above, they account for about 20%. Mr. Chan Pui-kon. Thank you, Chairman. The REA scheme, as at January 2026, have recorded over 66,000 participants. 60% of them were women. It shows that the scheme has unleashed women labor force effectively. I hope that the labor force will promote the scheme further as they launch the Good Employer Charter 2026, so that the more employers will hire elderly people. And we also hope that more employers will offer family-friendly employment practices so that they can retain or hire middle to elderly people, middle-aged to elderly people. I have one more question. I wonder if the Labor Department will look into including the requirements under the Charter in the procurement guidelines. This will further incentivize employers to join the Charter. Thank you. Deputy Commissioner, thank you. I thank Mr. Cheng for the suggestion. The goal for this charter is to instill a cultural change in the community and to encourage employers to attach more importance to good human resources management measures and family-friendly employment practices. We will continue our promotional efforts in this area. It takes time for us to see changes. Different enterprises may have different considerations. The enterprise's image would definitely be improved after they are being credited as the signatories to the charter. So I believe that there will be positive impact brought to the enterprise if they join the charter. Thank you. Mr. Ng Won-kit. Chairman, I fully support the Good Employment Charter, or Good Employer Charter rather. The Labor Department have been promoting family-friendly employment practices and good communication between employer and employee. But as our country is developing into a hub into international high-caliber talents, I think that we have to contribute. And I hope that the administration will enhance the positioning of the Good Employer Charter so that we can become a platform to retain and attract talents. First, I think that we can raise the importance of the charter to encourage more enterprises to offer flexible working arrangement and clearer career progression ladder. Second, as we are having more and more talent admission scheme, as there are more non-local talents coming, I think that we should offer inclusive. We should create an inclusive culture in our local enterprises. Third, I hope that the department can work with the Talent Engage so that we can turn Hong Kong into a symbol for good employment practices. This will not only enhance the labor relationships but also enhance their competitiveness. Thank you.
多謝
Deputy Commissioner for Labor. Thank you, Chair. Thank you, Mr. For the suggestions. The general vision is, with the promotion of good employer charter, more employers are recognized for their employment practices. It can be positive for them in recruitment and attraction of talents. Regarding specific suggestions of the member, we have a charter every 2 years. With the next charter, we will consider implementing some performance indicators. As for the suggestion to enhance the brand of Good Employer Charter, we agree. We will continue to enhance our work in this regard in participation as well as recognition of the Good Employer Charter, so as to enhance the brand of the Good Employer Charter. Thank you. Mr. Lam Wai Kong. Thank you. I very much support the Good Employer Charter, and I thank the Labor Department for working hard to promote the Charter. I have observed myself the Charter is very helpful in promoting labor relations. And in 2024, on top of the Good Employer Charter, we have the Good Employee Recognition Campaign. So I want to ask if the department in future, like the Good Employer Charter, will provide specific incentives for good employees and perhaps work with different organizations to provide better recognition of good employees. We have very good feedback for the reemployment allowance pilot scheme. I hope that the scheme can be regularized to unleash further potential labor force. We also have the employment scheme for middle age and the elderly. How can we work it better so that we can have more women and silver-haired groups join the labor force? Deputy Commissioner, thank you, Mr. Lam, for your questions and suggestions. On providing recognition to good employees, we'll think about how we are to go forward with this. I do think the member's point is valid. I understand the labor sector is very much supportive of this work, and they are trying to promote the election of model workers in different industries. I think we have the same goal here for different employees in different positions in certain industries. We want to recognize their efforts. We will continue to promote employment of the middle-aged and the elderly. We have launched the reemployment allowance pilot scheme about a year and a half ago. We're conducting the midterm review. The scheme is supposed to last for 3 years. We are going to consider the way forward with this midterm review. Let's see how we can better encourage employment of the middle-aged and the elderly. But let me say this. It is a heavy burden on the government in terms of money, so we want to be more targeted. We want to provide incentives to those who are actually going to rejoin the workforce after a certain period of unemployment. We have also enhanced our recruitment work. Recently, we have the dedicated website on promoting employment to disseminate more information on industries to promote employment of the middle-aged and the elderly. All right, all members who have requested to speak have spoken. The next item is any other business. There's no other business. Meeting adjourned.